case briefs, and so much more. LSData's got what you're looking for.
In a landmark case for Ohio's lemon law, the Supreme Court of Ohio upheld the rights of a car owner named Royster, affirming Toyota's responsibility for a defective vehicle. The law stipulates that if a new vehicle has recurring defects causing it to be out of service for a total of 30 days or more during the first year of ownership, the manufacturer must either offer a refund or a replacement. In 1996, Royster leased a new Toyota 4Runner. However, 9 months in, she experienced a persistent fluid leak, leading to the vehicle being towed to the dealership where it remained under repair for 55 days. Despite being offered a loaner car, Royster subsequently filed a lemon law claim against Toyota, which the trial court upheld. Toyota appealed the decision, contending that a reasonable number of attempts were made to repair the vehicle and arguing the use of a loaner car mitigated the inconvenience experienced by the owner. However, the Supreme Court of Ohio overruled the appellate court's decision, asserting that the loaner car is not a statutory defense under the lemon law. The court agreed with Royster that having her car out of service for an extended period constituted a significant impairment, despite the dealership's attempt to make amends with a loaner vehicle. The judgment was in favor of Royster and against Toyota, maintaining that a repair timeline exceeding 30 days in the first year of ownership justified the implementation of the lemon law. Furthermore, the court granted Royster the possibility of additional attorney fees, sending the case back to the trial court to reassess these costs. This case affirmed that consumer protection laws such as the lemon law could provide significant restitution for consumers, even against large corporations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.